Initiative.
It's a wonderful initiative.
The Global South Network opened new horizons for judicial cooperations.
Global South Network provide a platform for meaningful dialogue and collaboration, fostering efforts to build a more equitable and resilient legal landscape.
GSN network continues to expand areas of activity, further strengthening its impact and reach.
The universal concept of justice compels us to join our efforts, and this is the forum for promoting the same goal.
Well deserved for the hectic activity you have made. I am astonished, I am amazed, I was impressed.
May I at the outset commend you, Dr. Ayat, for the immense work that you're doing in the GSN. The Global South Network is a much admired initiative.
كانت جزء لا يتجزأ من الدولة العثمانية.
We are being criticized for doing our job and for upholding the federal constitution. Like I have said in the past, I will not bend to such lame pressures and insinuations.
It's commendable. South Network focuses on all disciplines and regions, creating a bridge between academia, civil society, legal community, etc.
Quiero expresar mi sincero agradecimiento al Dr. Nauman Riad.
Dr. Nauman Riad, the founder and convener of the Global South Network. His visionary leadership has established a vibrant forum where judges, academics, and practitioners from around the world can share and exchange ideas.
I would like to point out that Dr. Riad's initiatives have not only enriched comparative judicial dialogue, have also fostered mutual understanding of the diverse challenges that courts face in safeguarding the rule of law and constitutionalism.
We can rule when we want in the cases which are brought to us by citizens.
After all, what would you do as a colonizer from the global north, conditioned by a systemic othering mindset and driven by economic lust built on commodification, including the commodification of human beings?
My name is Dr. Nauman Riad, and I have the privilege of serving as the founder and chief convener of the Global South Network. The Global South Network was established precisely to encourage this kind of conversation, one that transcends geography and legal families, connecting North and South, East and West, theory and practice. Our goal is to create a safe, inclusive, and intellectually vibrant platform where judges, scholars, and students can engage critically with the pressing legal questions of our time. Today, we are deeply honored to host the Honourable Justice Professor Dr. Andras Varga, President of the Curia Supreme Court of Hungary, who will be delivering a lecture titled Limited Precedent System and the Impact of Common Law on Adjudication, Evidence from the Curia of Hungary.
I would like to express my sincere gratitude to the Global South Network's founder and chief convener, Dr. Nauman Riad, for inviting me to speak before you today. Complete uniformity in application of law is conceptually impossible. The fundamental law of Hungary, the constitution, makes it the task of the Kuria to ensure this uniform application of law by the court. The view of Europe in the 19th century was of a very strict positivistic nature, that the world around us is objective and it's understandable, it's comprehensive. Law is a social phenomenon. Law is also objective and it's also comprehensible. What was the outcome? We saw that hence the word is objective, hence the words are objective. Consequently, every word has only one perfect, meaning if a judge is correct, is legitimate, and is honest, then will deliver the judgment based on this formal and strict interpretation. In brief, the judge is only the mouth of law. The judge became a more active actor. The plaintiff had an interpretation, the defendant had an interpretation, and the judge has an interpretation. To be frank, I have to say that it's another influence of the common law to Hungarian law system that our system of precedents works. And we don't lose our identity if we gather other practices, if we include some other interpretations. Why? Because identity is not a static question. Our legal or constitutional identity was not the same in the 15th century or the 14th century or the 16th when Hungary was occupied by Turkish troops for 150 years. That time the identity question, of course, was different than in the 18th century, and everything was restored when the Curia was set up as a permanent court, when we got this planum tabulare I mentioned. Not the same as in the 19th century. This last question is not so easy, a bit complicated. If a jurisdiction repeals the solution of other jurisdiction, sometimes it's not because they don't understand or they are reluctant to accept new ways. Perhaps it's simply not important. Thank you very much, Dr. Neumann Rayat, for the invitation, and I want to assure you that the privilege was mine. Thank you very much for the invitation.
Thank you. Bye-bye.